Hi, I'm Barbara Coombs Lee, the president of Compassion and Choices. I'm here in Helena, Montana today. I have just sat through the oral arguments of Baxter versus Montana, our case before the Montana Supreme Court that argues that terminally ill, mentally competent, dying Montanans have a right under the state constitution to ask their doctor for medication that they could take at time of their own choosing if their suffering became unbearable and they chose the time to die. It's exciting to be here. The courtroom was filled to overflowing. There are press everywhere, and I wanted to give you my first impressions of how the arguments went and what we might glean or suggest from the questions of the justices. First of all, the attorneys who argued on our side, the attorney who argued, Mark Connell, an attorney from Missoula, Montana, did an excellent job. He just knocked the ball right out of the park a few times in response to the justices' questions. He was passionate, he was astute, he was compelling. I would say of the two attorneys, and I admit that I'm biased, but I would say that the attorney representing the state, Anthony Johnston, did a very capable job, but he did not have the passion and the compelling arguments on his side, and I would say that Mark really did put in the better performance before the court today. There were a few indications of how the court might be thinking, the questions that were on their minds, and I think that we dealt with those very well. One thing that is clear, I would say, for the majority of the 7 justices, do not buy the argument that there is a clean and bright line between palliative care and the delivery of high-dose medications at the end of life that cause death, but the doctor does not intend to cause the death, and actual aid in dying, where the power and the control is passed to the patient to choose death at a time of their choosing if their suffering becomes unbearable. The state wanted to argue, and did argue, that that is a very bright line, and that is the policy line that the legislature adheres to. At one point, Justice Cutter, who may very well be writing the opinion for the court, said, "So do you mean to say that a criminal prosecution should hinge on the candor of the physician?" So it's clear that the justices realize that there is no real bright line, and perhaps the logical extension, of course, from our perspective, is that the control and the choice should reside with patients, because they are the best judges of the severity of their suffering and the quality of their lives. I think that that was an opinion that was shared apparently by some of the judges who talked very passionately about their dignity clause that is in the Montana State Constitution, about what it means to be born with dignity and live with dignity as a human being and die with dignity. The justices want to give effect to that dignity clause. The state wanted to argue that the dignity clause, it really has no effect outside of overt state discrimination. I don't think that the majority of the justices buy that argument. It seems as though the justices see dignity for Montanans as a special and distinct right that they may give effect to today in their deliberations. There's one justice, Justice Rice, who was very concerned about the state's interest in protecting life, and I think that that's another instance where Mark Connell really responded very well in talking about how, yes, of course, the state has a right to protect life, and the state's interest in protecting life is at its greatest when there's young life with a life to live ahead of it. But when a life has been lived, and when death is imminent, and when there is nothing left but a very short life and a life of intense suffering, what could possibly be the state's interest in prolonging that death and protecting that very short life of misery in contravention of the patient's own desires? I think that that was a very compelling response. We didn't hear very much more about the state's interest in preserving life after that. So We are, of course, cautiously optimistic. There are 7 justices. We think that there are 2 for certain, 3 quite likely who may not see the case our way, but we are hoping for a majority to rule, and hopefully rule soon, on a constitutional protection for aid in dying for all Montanans. Thank you so much for your support for Compassionate Choices as we do this work.